Contract signing seems straightforward, but getting it wrong can lead to serious legal complications for both you and your company. Understanding who has the authority to sign contracts on behalf of a business is crucial for protecting all parties involved. When a business becomes incorporated, it transforms into its own legal entity. This means the owner can no longer simply sign their own name on business contracts. Instead, this responsibility falls to authorized representatives who have been granted the legal power to bind the company. There are two main types of authority that allow someone to sign on behalf of a company. Actual authority occurs when a person has been explicitly authorized to sign. This is typically documented in writing through corporate bylaws, board resolutions, or formal delegations. Apparent authority, on the other hand, arises when a company's actions reasonably lead others to believe someone has signing power even if no formal authorization exists. The rules for signing authority vary significantly depending on your business structure. In a sole proprietorship, the owner has complete signing authority since the business is not legally separate from the owner. For partnerships, general partners can typically sign on behalf of the partnership, while limited partners cannot bind the business with their signature. Corporations operate differently. Signing authority often rests with the chief executive officer or president. If someone signs without proper authority, the corporation will not be bound to that contract. For limited liability companies, managers or members usually have signing authority, which should be clearly outlined in the operating agreement. Many businesses create problems for themselves by failing to define signing authority in writing. Verbal agreements about who can sign what often lead to confusion and disputes. Another common mistake is allowing implied authority to expand unchecked, where employees gradually take on more signing power than intended. Companies also frequently forget to revoke authority when employees leave or change roles, creating potential liability issues. When signing disputes arise, courts examine various factors to determine if apparent authority existed. They'll look at the agent's past conduct, their job title and duties, and whether the contract was a consumer or business-to-business agreement. These cases can be highly fact-intensive with unpredictable outcomes. The risks of unauthorized signing extend beyond the company to the individual who signs. Someone who signs without proper authority may face personal liability for the contract's obligations. They could be personally sued if the company refuses to honor the agreement and might face accusations of fraud. This can damage their professional reputation and lead to employment consequences. To properly sign on behalf of a company, always use the official company name exactly as it appears in legal documents. Include your title to clarify you're signing as a representative rather than in your personal capacity. Avoid any wording that suggests personal liability and be aware that some states have specific requirements for business contract signatures. When executing contracts, always date your signature and ensure all parties do the same. If last-minute changes are needed before signing, the best practice is to print a new revised contract. However, handwritten changes with initials or formal addendums are also acceptable. Each party should retain copies of the signed agreement, whether signed in ink or electronically. To avoid signing authority problems, companies should establish clear written policies about who can sign what types of contracts and for what amounts. Maintain a centralized contract management system to track all agreements. Consider implementing approval workflows for high-value contracts and provide regular training to employees about their signing authority limits. Understanding contract signing authority protects both your company and yourself from unexpected legal complications. By following these best practices and establishing clear policies, you can ensure contracts are properly executed and enforceable while minimizing disputes about who had the right to sign.